afternoon and welcome to CUHK Law and the latest in our Greater China Legal History seminars. Thank you very much for joining us today, and it's great to see friends from all over the world. Some who've obviously got up very early in the morning. It's very nice to see you, Chris, over there. So thank you for joining us for the final in our Greater China Legal History seminars of this year. Also, apologies because this, of course, seminar we did attempt before, but we had a couple of gremlins with the technical matters, and so we had to postpone the seminar. So we're very pleased that our colleague, Professor Leng Lim, has come back again today to present this seminar. And again, thanks to all of you for rejoining, and also to some new participants that we've also got joining as well. Anyway, I better introduce our speaker to you. Our speaker today is my colleague, Professor Leng Lim. Professor Lim is one of our chair professors. He's the Cho Ming Lee Professor of Law, and he practices as a barrister and an arbitrator with a leading London commercial set. He's a visiting professor at King's College London, honorary senior fellow of the British Institute of International and Comparative Law, an editorial board member of the International and Comparative Law Quarterly, and an associate member of the Institut de Droit International. His latest book is Treaty for a Lost City, and that's what he's come to talk to us about today. So if you haven't got a chance, I don't know if you can see the copy. He's going to be talking about this book. I can recommend it to you, as I've already read the book, and he was very kind and gave me a copy of the book, and I've read it. And now I'll hand over to Chin to talk to you about his new work. Over to you, Chin.
Thanks very much, Steve. I hope you can hear me clearly. And thank you to Jay and to Alan, to Lutz, who hopefully will be able to join us after his meeting, to everybody who's come back, and for being here the last time, and to Chris. It must be 4 o'clock in the morning over there, Chris Gaynor, former dean. And thank you to everyone who wrote to me after the last abortive session saying, don't worry, I think we can wait. So that was very encouraging. Thank you. I think if we can move to the second slide, that's basically what the book looks like in the cover. So let's see. My colleague Alan is helping me with this, and it's very kind of her. That's what the book looks like. And if we can move to the next slide, the third slide, that basically is a reproduction of the table of contents. And as I mentioned the last time, I'm not going to do this in the usual manner where I go through the book tediously, chapter by chapter, saying this is what I say in this chapter, and then this is what I said in the next chapter, because I think that's a little bit tedious, a little bit boring. And what I like to do is to capture some of the major issues in the book. And so what I'd like to do, I've laid out in an outline, which is in slide 4, and I think everyone's got the slides now. So if you take a look at slide 4, I'd like to start with a long introduction, and this introduction will probably take 15 to 20 minutes, if not more, where I make a number of points just to situate us. And once we get through that, it may take up to 25 minutes. I'll then give you an overview of the narrative in the book, the main plot, as it were. And subsequently, I'd like to get into what I call the diplomatic aspects as opposed to the legal aspects. And I think it's very important. To be very clear in our minds when we are talking about this instrument from a diplomatic viewpoint, and when we're talking about it as a legal instrument. Once we get past that, I'd like to get into some of the things that people are talking about in the press today. It includes going back to take another look at the interaction between the Joint Declaration and the Basic Law, but also issues like, was Hong Kong a colony? And there's been some public debate about that after the book was published, actually. And there is also an article, quite a recent article in the South China Morning Post, where someone, a well-known columnist, said, maybe we should just suspend the Joint Declaration. And so it'd be interesting to ask, what does the book say about these things? I'll then round up with a whole bunch of smaller points, including what we mean when we say this is a binding treaty. How do we feel about English judges sitting in Hong Kong, and not just English judges, Scottish judges, Canadian judges, and so on. And then I'll round up by looking at 6 book reviews which have appeared in the first 6 months since the book was published. And there are at least 3 more reviews I have heard of that are appearing soon. But let's get into the introduction. I'd like to talk about 3 things in this introductory part. And the first is how the book came about, because I think it makes it easier to read a book if you know how the book came about, why it was written, what was the person thinking in writing this book, which actually was a very real issue for me, because a lot of people said to me, you shouldn't write this book. Are you mad? This is not the time to be producing a book like this, because everyone's feeling very passionately about some of the issues, and there's a great public controversy. So why did I write a book at the time? And the second issue I think of as the Joint Declaration's, what I call constitutional indifference in Hong Kong itself, in the sense that if you read a lot of court judgments, you don't see the judges talking about the Joint Declaration. And why is that? And different people can come up with different answers, opposing answers to that question. And the third introductory point, which I think is quite a fundamental one, has to do with the nature of this treaty. It is a treaty, but what is the nature of this treaty? I think in the popular public impression, it's this pristine constitutional charter where all our rights are assured, and we expect it to work as we assume it should work. But when we look at the negotiating history, and this is what the book really is about, it goes back into the past, you can see what an idealistic notion that was. But that is beside the point. Was it in the first place this pristine constitutional charter, or was it something else altogether? But it had to be presented in a certain way, which then creates this public impression of what the document is. So getting firstly into how the book came about, well, I was conscious that it was going to be the 25th anniversary. And coincidentally, certain British records in the National Archives had recently become accessible, not just in England. It was in the middle of the pandemic, and I was trying to figure out how I could get to London to get to these records. And it was actually a former colleague at Hong Kong University, where I had taught for many years, who said, this particular set of records, I think, has just been purchased by the Hong Kong government. So I went to check. And in fact, wholly coincidentally, in the thick of the pandemic, these records were now located as well in Kowloon. So I immediately went to Kowloon, and there they all were. And before you knew it, my living room was filled with stacks and stacks of telegrams from decades ago. And since it was the pandemic, it was time to sit down and at least write a book. So that determined the timing to some extent. There wasn't much travel or moving around from point A to point B. I was just sitting at home, and I started writing the book. So it was written in a matter of a few months in the first year of the pandemic. But my interest in this subject, in this treaty, was triggered around 2014, 2015. It was then that I wrote a piece of heresy in a journal called the Law Quarterly Review in England. Of course, I already knew something, or thought I knew something, about the treaty from the 2000s. And that was because in the 2000s, I was coming to Hong Kong to live here permanently. I was previously only a visitor to Hong Kong, although I was a fetus in Hong Kong, but I don't think that counts. I was coming to Hong Kong, and I was being told that I was coming to Hong Kong to take charge of teaching constitutional law, that's what we call it, which essentially is the basic law at Hong Kong University. And so I was coming in blind, you could say, or worse than blind. I was coming in as a person who had taught a number of Commonwealth constitutions over several years, and who had taught constitutional and administrative law some decades ago in England, where I began my career. We then started calling it public law. I think it was a more fashionable way of referring to the whole subject. But if you knew something about how the Constitution worked, teaching the Constitution at London University, and then you went out into the Anglo-Commonwealth world and you taught a number of Commonwealth constitutions, you're going to have a certain set of assumptions about how a constitution is supposed to work, and particularly how a constitution is supposed to work in a former colony. And you could go in with all these assumptions and just proceed upon that footing, except that I knew, at least realized, how much I didn't know, because I had no experience of socialist legality. I had no idea how the Chinese legal system actually works. And so in the 2000s, that was the real challenge. You had to teach the basic law, and you could just pretend that this essentially is a document that can be taught in a very British way, or you can start from a completely different set of assumptions, and you can say, well, I don't know what this thing is, and I still have to figure out how this thing should be approached. Anyway, through years of experimentation teaching this subject at Hong Kong University, I managed to get to 2014, 2015, when people started to say very interesting things, not the British government, but people in London started to say very interesting things around 2014, 2015. Lord Patten, for example, started talking about British treaty rights. And I found that really fascinating around 2014, 2015. And I wrote a very short piece in the Law Quarterly Review, putting treaty rights in quotation marks. And the piece was called, what was it called? Britain's Treaty Rights. Something like that. To me, I was writing a boring legal piece. It was a piece of legal orthodoxy. And the reason I thought, and still think, that it is a piece of legal orthodoxy is because international law is a little bit different. And the way you interpret a treaty is a little bit different from the way you might interpret an English contract or a Hong Kong contract. In international law, what one party to a treaty does after the treaty has come into force, if implicitly what it does is met with acceptance by the other side, then what that first party does in terms of how it approaches the treaty becomes what we call subsequent practice. And that subsequent practice can determine the interpretation, the proper interpretation of that treaty. And that's something that comes from Article 31 of the Vienna Convention on the Law of Treaties. And if you put all of that together, what you get is this possibility that if you have had Chinese subsequent practice, say, standing committee interpretations of the Basic Law, where the Basic Law implements and is intended to implement the Sino-British Joint Declaration, what you essentially get is that what the Joint Declaration now means is partly how it has been implemented and viewed over time by the Chinese central government. Now, why was I going about saying things like that in the Law Quarterly Review in the first place? Because what is the Law Quarterly Review? The Law Quarterly Review is a journal which a lot of barristers subscribe to. You always know when the Law Quarterly Review is out because you see all these volumes in pigeonholes in barristers' chambers, and law schools subscribe to it. It's not seen as a journal that takes flights of fancy, put it that way. Judges cite it. Why was I saying this in the Law Quarterly Review? Well, obviously because I wanted what I said to be read in London. And what I was really saying was, well, if we're looking at things from the perspective of 2014, 2015, and there have been a number of years that have passed since the handover, and you've had the Standing Committee of the National People's Congress issue interpretations, and the United Kingdom hasn't really come up publicly to say, well, we don't agree with that. Then implicitly, or you could say implicitly, this subsequent practice in the implementation of the treaty has been accepted. Now, that's just a suggestion. And if that is correct, then the meaning of the treaty has been clarified over time, but it has been clarified by Beijing's practice. And so the question that was left hanging was, is it not too late for some people in London to be getting up and to say, oh, we want to talk about Britain's treaty rights? Now, I didn't answer that question. I just posed the question by writing the piece. But you can imagine that while this was a piece of international legal orthodoxy, this was international law, and I stress again, LAW, this was just a legal piece. And the point of law that was being made is written in the Vienna Convention on Law of Treaties, you could say plain as day. It was bound to be controversial. And a very distinguished British scholar, as I said before, the last abortive session terminated. I don't use that term often. A very distinguished British scholar called Dr. Ewan Smith, who had spent many years at the Foreign Office in London. He decided to write something about what I just said, which to this day is not formally published, although it is publicly available. And I had read it around when it was written, and it's still out there in the public domain. And he probably is today the United Kingdom's most authoritative person on constitutional treaties. Well, he criticized, and he criticized me in a very gentle way, very gentlemanly way, by saying this can't be right. This is completely wrong. what this Lim chap says must be wrong. It must be wrong because the way we should approach the Joint Declaration is to expect Hong Kong judges to use the treaty to guide them in how they should interpret the Basic Law. And that makes perfect sense from the viewpoint of constitutional law if you were teaching it from London. Because there was a time when the European Convention on Human Rights had not been implemented in domestic legislation in the United Kingdom in a period prior to the Human Rights Act. And I had taught the law then in England and Wales before the Human Rights Act. And I saw the Human Rights Act being passed and how we had to change the way we taught subsequently. But there was a time before the Human Rights Act was passed when if you had a complaint against the United Kingdom government, you couldn't bring it to a British court because the European Convention on Human Rights had not been implemented in the United Kingdom prior to the Human Rights Act. And so it made perfect sense for the House of Lords to say, you know, we should approach even the interpretation of statute by keeping the European Convention on Human Rights in mind, even though it has not been implemented in the United Kingdom. So if you came with all these assumptions that the way we were supposed to understand things in Hong Kong, you know, is the way they would be understood in London, then what Ewan says makes perfect sense, and I must be completely wrong. Well, if I was so wrong, what possessed me to write what I wrote? The reason is because the Joint Declaration has been implemented in Hong Kong law, and that instrument which implements the Joint Declaration is the Basic Law. And there is something about the Basic Law that made me write what I wrote. And that something is the Basic Law saying, in a provision which I think many people in the audience know, which is Article 158, that the Standing Committee, the National People's Congress, has the power of interpretation. This is a very tricky provision. So what you have is a piece of implementing legislation which says, whether, you know, whatever people might think about it, which says that the NPCSC has the power of interpretation. Now, that partly explains why, if you were a Hong Kong judge, you wouldn't be second-guessing the NPCSC precisely because the Basic Law says the NPCSC has the power of interpretation. If you went to the treaty to judge for yourself what the Basic Law meant, then you risk ignoring Article 158 of the Basic Law. That was the basic puzzle, which suggests that the way we approach the Basic Law is and ought to be indifferent to the Joint Declaration. Because if there is doubt, instead of going to the treaty, it should go to the NPCSC. That's the basic reading of Article 158. If you ever read this book, Treaty for a Lost City, I have something to say, and this was part of the excitement in writing this book. I have something to say about how the United Kingdom side not only knew that all of this was going to be the case. I mean, they knew in the 1980s that all of this was going to be the case, that you had this issue about who should interpret the implementing legislation, whether it would be your autonomous judges in Hong Kong, autonomous judges, so-called, or whether it would be what the Foreign Office in London referred to as the center, which would have the authority to interpret the Basic Law. They were aware, they were alive to this issue. They discussed it. My impression of it is that they didn't think it was that controversial. That if you have a central authority and a regional authority, then the relationship between the central authority and the regional authority must be decided not in the region, but at the center. That was how they framed the whole issue within the Foreign Office. And there is an internal document in particular that I've put in the slides, but I will come back to it. This is just to flag the importance of a particular document, which I'm putting across merely to show that London was alive to the issue. They weren't asleep on the switch. Okay? But even after the Joint Declaration had been concluded, of course, the Basic Law still had to be drafted. Now, at that juncture, in that second phase, the United Kingdom returned to this same issue. Now to try to shape how the Chinese authorities were going to write out the Basic Law. Now, as far as the Chinese side was concerned, well, passing legislation is something that domestic authorities do. It's not something that two countries do together, you know? You don't help me pass my legislation. This is something I do. Now, if you have something to say, you, the United Kingdom, the only channel that's open to you to express yourself is the diplomatic channel. That there is no legal process where the United Kingdom is co-author of the Basic Law. But nonetheless, if you were in the shoes of the United Kingdom, you would want to try and shape the way the Basic Law is written. And what the United Kingdom wanted during that second phase was exactly what Dr. Ewan Smith had said in his criticism of me. What they wanted was a clause in the Basic Law which says that if there is any doubt about what the Basic Law means, then you should go back to the treaty. You could say, and the reviewer, very kind reviewer from Shantung in the China Review just some weeks ago, highlighted this point in my book. You could say that if the United Kingdom had succeeded on this second try, it would have succeeded in tying China's hands in relation to another treaty, in relation to Hong Kong. I put this quite delicately in the book, and if we can have slide 6, please, Alan, the 6th slide, which is the next slide, and this is page 79 of the book, where I say that declassified records show that following the release of the second draft of the Basic Law in February 1989, the United Kingdom had proposed to the PRC through diplomatic channels that a new article should be inserted to, quote, make the Joint Declaration a reference point for interpreting and for limiting amendments to the Basic Law, end quote. Now that proposal failed, so it failed the second time round. And I go on to explain in the book that primarily, the United Kingdom government in this second phase was concerned about amendment, but it was also concerned about interpretation, and that there is actually quite a fine line between interpretation and amendment in the Basic Law. But put bluntly, it was to tie China's hands again by another treaty. In the end, the Basic Law was to provide in Article 158 that despite the Hong Kong SAR courts having the final power of adjudication, the ultimate authority of interpretation to interpret the basic law would rest not with the courts, but with the standing committee. Now, let me just pause here, because I've had people over the years, having taught this subject over the years, I've had former students, I've had barristers say to me, but Professor Lim, that cannot be right, because if you are right, then the final power of adjudication means nothing. Nothing. What I'm saying is that the final power of adjudication cannot be read as if Article 158 doesn't exist. And again, it really depends on the lenses that we put on, because the final power of adjudication and the power to interpret a constitutional document may be two separate things in Chinese eyes, but one and the same thing in common law eyes. And so what you have is not an answer. What you have is a kind of puzzle, which can only be resolved. And I think it was resolved in the minds of people sitting in London as far back as the 1980s by answering the question frontally. If there is a question that arises about the relationship between the center and the region, where does the final power of interpretation lie? Does it lie in the region or does it lie in the center? As I said, this is a very delicate issue. Can we turn to the next slide, please, Alan? If we take a look at this particular telegram from October 1989, this was during the second phase. This was when the United Kingdom was trying to shape the way that China was drafting the basic law. And I quote, "Clearly, the first we have to consider are matters which give rise to the consistency of the draft basic law with the Joint Declaration." Now, I have 3 dots here. In this category 4, when you read the original telegram, it has all these various categories of issues that were of great concern to the United Kingdom. This was after the Joint Declaration had been concluded, but the basic law was still being drafted. And then you have other categories. Now, I'm not trying to suggest that the issue was clearly of secondary importance only to the United Kingdom, but it is interesting that you have all these issues which are seen to deserve mention first, and then you have this residual other categories sentence. Other categories of issues are those that relate to the relationship of the SAR to the central authorities and the workability of the provisions designed to give effect to the high degree of autonomy which the SAR is to enjoy. And to a certain extent, these issues are connected. The greater the extent of the autonomy, the more restricted the scope of the interrelationship between the authorities of the SAR and the center. And then you have a very important sentence, but the constitutive power of the center. How do I read this phrase, the constitutive power of the center? I read this to mean that the relevance of, say, the PRC constitution or the way the PRC constitution works is not limited to when we encounter foreign affairs or defense issues in Hong Kong. This reference to the constitutive power of the center goes to another highly controversial issue, which we've seen in the public domain. What is the relevance of the PRC constitution to Hong Kong? And one of the books that has been published on this issue, a book published by Springer, the German publisher, in one of a pair of books published on this issue in recent years, one argument or assertion is that, well, of course, this, much of the substance of the PRC constitution does not apply, would not apply directly to Hong Kong, but some aspects of the PRC constitution have relevance to Hong Kong. sometimes referred to as the structural aspects. But look at this telegram. It says, this has consequences for the power of amendment, the extent of legislative autonomy and interpretation. It also has consequences as regards the PRC constitution and the extent to which its structural provisions, as distinct from its ideological or policy provisions, have relevance in relation to, if not directly to, the special administrative region. And this is not something that was produced by the Chinese side. It's an FCO telegram dated October 1989. So that's what I have to say in this first point in my introduction, which has to do with something I call the constitutional indifference of the Joint Declaration. Now, many people may disagree with me. Former colleagues in Hong Kong University would point out to me, well, no, I mean, there are certain judgments, maybe scattered judgments, a couple of judgments you could pull out from the very early years when there are references to the Joint Declaration. But I don't think that affects the substantive point. We can come back to this. Let's put aside this point about whether the Hong Kong Constitution is truly indifferent to the Joint Declaration as a document that you would need to look to, or as a document which you should even look toward if you had any doubts about the interpretation of the Basic Law, particularly in light of the need as well to interpret Article 158. Let me come to my second point in this introductory part, which is the nature, which has to do with the nature of this treaty, this joint declaration. The main thing that struck me about the negotiations themselves, which is what these archival records, which form the heart of the book, are about, the main thing that struck me about the negotiations was that the joint declaration was put together very hurriedly. That itself causes me to question whether it's this comprehensive, this pristine Charter of Rights, if it was assembled almost as an afterthought. I say this because we have the impression, as I've mentioned, that it is instead something else, something other than a hurried document. It is this comprehensive entrenchment of internationally assured rights, which will ensure a way of life in our minds to last for a half century. That's the public impression. And there were very important reasons why that public impression had to be fostered, why it had to be nurtured for the sake of Hong Kong. But the question is whether that public impression may at some moments be misleading. We have the impression that we have a pristine constitutional treaty that was very carefully thought out, very carefully elaborated upon, with all the fullness that it deserves, and no doubt that must have been the aim, at least on the British side. And I myself couldn't go through the archives and not come away with respect and admiration for people like Geoffrey Howe. I thought he was brilliant in putting this together as a fallback position. And I would include in that my admiration for Percy Craddock, who showed extraordinary statesman-like qualities in very difficult moments during the negotiations, because, of course, those in the audience who have had experience of diplomatic negotiations would know that your own side need not be cohesive. And it certainly need not be cohesive at all times. There are many, many viewpoints from the same side in any complex set of diplomatic negotiations. I don't wish to take anything away from what Geoffrey Howe had accomplished, what Percy Craddock had accomplished. But the reality was that the Joint Declaration as we have it was Plan C. It wasn't Plan A. It wasn't even Plan B. If you had a Plan A, and the Plan A was continued British sovereignty, and people had devised all kinds of ways, which may or may not have made its way into the negotiations, but it was out there in the public domain as the treaty was being negotiated. And people were devising ways of justifying British sovereignty, but that position collapsed very quickly. It really was about Plan B. Plan B was not about British sovereignty. Plan B was, all right, okay, so you say that you're sovereign, you're China, you're sovereign, fine, you're sovereign. That's Plan B, but we will continue to administer Hong Kong. And Plan B collapsed. And so when Plan B collapsed as well, you had Plan C, and Plan C is basically what we call the Joint Declaration now. Because Plan A and Plan B had collapsed in fairly quick succession. And you had a very tight window. You didn't have all the time in the world to conclude these negotiations. You had 24 months from start to end. And so if you had 24 months and 1 year into the negotiations, 12 months into the negotiations, your Plan A and Plan B had collapsed, then it was always going to be a strain, not only to put a treaty together, a treaty which on the Chinese side, the People's Republic of China considered to be completely unnecessary, but also a treaty which you could then present to the world as this pristine, comprehensive document that I've mentioned, this pristine Charter of Constitutional Rights. A document which would envisage all the strains you couldn't possibly imagine for the next half century. And you had to put it together in less than 12 months. At a time, and we're talking about October to November 1984. No, sorry, October to November 1983, at a time, around the time of the 5th and 6th and 7th rounds of negotiation, when the negotiations were about to collapse. There was a great risk 1 year in that the entire negotiations were going to collapse and there would be nothing. In fact, the Joint Declaration as we know it was in the United Kingdom's own internal language, what they called Option D. And here I would mention two telegrams, one dated the 24th of September 1983, and the other the 29th of September 1983. And Alan, I wonder if you can have slide 8, please. Thank you. This comes from the book. So I give you in slide 8 an extract from the book first, because you need some way of entering into these important telegrams. The 24th of September 1983 was to become a critical turning point. To Sir Percy Craddock in Beijing, a further fallback plan was now required, which would have to involve discussing the Chinese plan positively. However, or to quote, the breakdown will occur during that round, end quote. There previously had been 3 options: A, continued British administration; B, accepting the Chinese plan; C, this is using the British language, as opposed to my plan A, B, and C language. They had a plan A, option B, option C, option D language. Option A was continued British administration, because by September 1983, continued British sovereignty was off the table. The only question was, as far as the British side were concerned, whether they were going to get continued British administration. And the way the arguments were made were sometimes quite fantastic. You had this question about the new territories lease, for example, expiring. And so you could imagine people at Hong Kong University devising the argument that, well, if you say that that was an unequal treaty, then there is no termination date for a lease, is there? Which must mean that we can still continue to administer all of it. Those were the kinds of arguments that were being devised. So a lot of thought was going into continued British administration. And that was option A, because British sovereignty as an option was gone. Option B was to accept the opposite view, which was the Chinese plan. And the Chinese plan was, we're taking Hong Kong, you can go away now, please. And what Percy Craddock said was, no, let's go for option D. We concede on the point of sovereignty. Okay, you say you've always been sovereign. We don't say anything about that. We just say you are sovereign. But if we say that you are sovereign, then what do we get in return? And that was option D. And coming back to this passage in the book, let me read it. Option C was accepting the Chinese plan, but to explore what flexibility there might be in the Chinese concept of administration and what guarantees in the form of continued British links the Chinese will be prepared to build into their plan. Okay, so British sovereignty was off the table. Now option A was continued British administration. Option B was Chinese sovereignty and administration. Option C would be, yes, we accept Chinese sovereignty, but let's just explore what British links of authority can be preserved. Craddock's view was that breakdown was not inevitable. We can still save it if we go for option C. We accept Chinese sovereignty and we look for ways of preserving British authority. And the United Kingdom should explore the last option, option C, that is to say PRC sovereignty, no British administration, but to seek to preserve British links of authority. That is what is meant when today we read statements coming out of Beijing, when they use this formula, when they say there are no links of British authority. They're constantly using this formula because they know London side can hear what they are quoting. Craddock added, I realize that this is a serious step and that EXCO, which is the local executive council in Hong Kong, will find it difficult to contemplate. The governor of Hong Kong will no doubt give his views on how they should be consulted, meaning how EXCO could be consulted. As far as London was concerned, EXCO was as much an obstacle to be circumvented as much as it was on side with British plans. While it might be thought that such a step should be considered only after the breakdown of talks, it would, in Craddock's view, create an unacceptable risk, since the United Kingdom would then have nowhere to fall back upon. You could say, why should the United Kingdom accept what it called option C, which was to concede on Chinese sovereignty, to concede on British administration, and to only seek to explore British links of authority because the talks would otherwise fail? Why don't you wait until the talks collapse and then you explore option C? Craddock, I think, must have been right. But if you had done that, you would have nowhere to fall back upon. You would not have a strategic retreat. You would have chaos. And your position would fall apart in full public view without a plan for a proper retreat. Now, just to spoil the story a little bit more by telling you how it ends, because I will come back to this. What happens next? What happened next was that Craddock then wrote to London with a proposal. And this proposal is reproduced in slide 9. And slide 9 refers to a particular telegram dated the 17th of November, 1983. The corresponding pages in the book, the corresponding pages are pages 34 onwards. And this part, I think, is critical. Craddock writes, I wish to make it clear on instructions that the British side understands that the Chinese plan is based upon the premise that both sovereignty and the right of administration over the whole of Hong Kong should revert to China after 1997. And for this reason, the British side does not intend, in the course of the discussion proposed in the Prime Minister's message, to make any proposal on links between Britain and Hong Kong. Hold on. What you're suggesting now is, after adopting option C, which is to seek ways to preserve British links, you are now proposing, Sir Percy Craddock, that we drop all mention of British links of authority altogether. To make any proposal on links between Britain and Hong Kong which conflicts with the premise that both sovereignty and the right of administration over the whole of Hong Kong should revert to China in 1997. In particular, the British side does not intend to propose any link of accountability or authority between the government of the Hong Kong SAR after 1997 and the British government at any level. The British side would also be working on the assumption that any British subjects who continue to serve in Hong Kong as government officials would be in the employment of the government of the SAR and would owe their loyalties to that government. Now, what I have not been able to trace is London's response. But what I did find was that this proposal by Craddock, that this be said to the Chinese, was said to the Chinese side during the 5th round, during the 6th round, and from pages 34 onwards in the book, there is an extensive discussion of what happens thereafter in the 7th round of negotiations. And it's not in the slides, but let me just read to you Craddock in another telegram on page 35 of my book, to quote, "This was perhaps the most positive session." And this was the 7th session. "It would seem that the formula presented to the Chinese side on 28th of November, taken together with the Prime Minister's message of 14th October and subsequent explanations of it, have finally brought the Chinese to the point where they are ready to discuss practical matters." So he had saved the day. The negotiations would not collapse. And from the 7th round of negotiations in late 1983 onwards, they proceeded within a few months to elaborate upon what I call Plan C, what they would call Option D, which is what we now have, which is this idea that we have this beautiful constitutional charter instead. And it's just as good as British sovereignty. It's just as good as British administration. It's just as good as British links of authority. Everything will be well for 50 years. And it's very important to say to people that things will be well. Can we have the next slide? Slide 10, please, Alan. Now, there is a weakness in my book. The weakness in my book is that you hear the British side speaking privately amongst themselves, because I've dug out all these telegrams, but you don't hear the Chinese side speaking. And so the Chinese side, in the impassive way they are presented through the British telegrams, look confident and assured, whereas there's all this doubt, even occasional skirmishing on the British side. I say in all this, China's negotiators might come across as certain and confident, but this is only because, but for the occasional speaking role granted to them in the UK records, The files show little other than the silent gleaming splendor of the national emblem above the Zhongnanhai's south gate. You have this impassive, confident exterior on the Chinese side, only because I don't have Chinese records, I have British records. In stark contrast, doubt and frailty, even occasional bigotry at the rag end of colonialism are laid bare in the files. But why would I reproduce things like that in the book? I say my only defense is that I have not set out to flatter my reader. So, to begin to wrap up this long introduction, it's been a very long introduction, but it's always good to have a proper footing from the very beginning. We're essentially looking at a range of familiar events. Everybody believes they know exactly what happened. We don't even have to look at the records. We all, ourselves, individually, we know what happened. But what I wanted to do was to look at what happened from the viewpoint of two countries, each acting in their own interest. The book is partly about how the Joint Declaration must be one of the most misunderstood treaties in recent memory. And let me just show you one example of how misunderstood it is in the popular perception. And what I'm trying to do is to show that the popular perception and what actually happened may be slightly different at critical points. Can we have the next slide, please? Slide 11. One need not go so far as to say that had the United Kingdom and China airshipped a poodle and called it a treaty, the UN Secretariat simply would have filed the dog away politely. We don't have to go so far as to suggest that registering a treaty at the United Nations lacks any legal significance whatsoever. But let me read to you the United Nations Treaty Handbook. Where an instrument is registered with the Secretariat, this does not imply a judgment by the Secretariat of the nature of the instrument, the status of a party, or any similar question. Thus, the Secretariat's acceptance for registration of an instrument does not confer on the instrument the status of a treaty or an international agreement if it does not already possess that status. Similarly, registration does not confer on a party to a treaty or international agreement a status that it would not otherwise have, end quote. The treaty is not a treaty because it is registered with the United Nations. That has no bearing on whether it is a treaty. It is a treaty because China says so and the United Kingdom says so. So that concludes these introductory remarks. I move on to swifter things, the overarching narrative. So the overarching narrative, if you take a look at slide 13, please. Alan, please, slide 13. Between March 1983 and September 1983, the assertion of UK's sovereignty under two treaties and the UK's fallback position, continued British administration, had both essentially collapsed. Then, afterwards, there were British initiatives on rights and liberties. There were British initiatives on democratic reform. But this was after the deal had been signed. You had these initiatives on entrenching rights in Hong Kong. You had initiatives on democratic reform, all done after the Joint Declaration had been concluded. Now, let me just pause here. Why is this important? Because people say, oh, you know, democratic reform, it's in the Joint Declaration. They say, oh, all our rights are protected. It's in the Joint Declaration. And we say it so often that often, if you say something often enough, it becomes true. Regardless of the fact that we might live in a world where if everyone on social media agreed that God exists, then we wouldn't need theology as a subject. God would exist because we've said so on social media. So there were all these initiatives which are very important to people, and they affect the idea that Hong Kong's way of life would remain the same. So there's a question of what the critical date is. What is the critical date when you say that Hong Kong's way of life will be preserved? Is it 1984 when they concluded the treaty? Or is it 1997 when, after they've concluded the treaty, you could change Hong Kong's way of life just before you hand Hong Kong over? In terms of the book's narrative, after dealing with that issue, the book moves on to deal with battles over having a court of final appeal. And this links to the role that is discussed today of non-permanent justices. The book then goes on to talk about a period of constitutional liberalism, which comes from a paper which I wrote before the book came out, called Judicial Rhetoric in a Liberal Polity, about this golden era of liberal judicial discourse under the care of the Andrew Lee Court, with these incredible interventions, with someone I admire, Justice Bukhari. And you had some of the most fascinating constitutional judgments during that period, some of the most iconic statements that have come out of the Court of Final Appeal. Lawyers will find this interesting. And after that, the book goes on to deal with a very rapid sequence of events through the 2010s. The 2014 State Council white paper, which caused enormous amount of public debate, even public anxiety, I remember. The booksellers' affair. At the time when I wrote on the booksellers' affair in the Law Quarterly Review, of course, nobody reads the Law Quarterly Review, but people who read the Law Quarterly Review thought I was mad. Did you just write on that issue just as it was unfolding? Application of mainland law to the West Kowloon terminus. And then there was the extradition bill, of course, and we know all about the extradition bill, culminating in the national security law. So that's the arc, as it were. That's the narrative arc. And finally, in the closing chapters of the book, I deal with the aftermath of the national security law. How do we understand the aftermath of the national security law? How do you understand the reactions, the international reactions? How do you understand the United Kingdom's actions, which, to my view, were very carefully calibrated? If you look at it from the viewpoint of how international law applies to those reactions, there was a surprising amount of predictability applying a branch of international law called the law of state responsibility. And this is the branch of international law which has to do with what happens when someone says there's been a treaty breach. What are the kinds of legal consequences? What are the kinds of legal moves that are open to you? And what happened in the aftermath of national security law was, in a way, textbook. You could map it out by looking at the articles on state responsibility of 2001. So that's the narrative. Let me now come to the diplomatic aspects before I move on to the legal aspects. As far as the diplomatic aspects are concerned, what is a treaty is the fundamental question. Well, it is a political or diplomatic instrument. What do we use treaties for? To ascribe whatever purpose we wish, whatever purpose we wish the treaty to serve. We always say the treaty says what we want it to say. That is the diplomatic function of a treaty. It is a disagreement reduced into writing. This function is especially clear in the case of the Joint Declaration. In fact, the term Joint Declaration came later. in terms of what Plan C or Option D was supposed to be, the Chinese side thought, well, if you really want a piece of paper, we could have parallel declarations. The Chinese side will make a declaration, the British side will make a declaration, and that'll be at the end of the matter. Then can we have Hong Kong back now, please? Thank you very much. That was the Chinese position. And the compromise was that instead of having parallel declarations, you make your own declaration and I'll make mine, we'll say that our two declarations are joined together. Hence joint declaration, where each side effectively still makes its own declaration. And when you look at the joint declaration today, it's got one side, the British side, and it's got the Chinese side, and you've got these two declarations glued together. Now, if the United Kingdom wants to say that this is a rights charter and a democratic guarantee, then that has to be justified. Mainly because I don't think the guarantees take place in the joint declaration. They take place in instruments like the Bill of Rights Ordinance, which incorporated into Hong Kong law the provisions of the ICCPR. Now, the Chinese side says there's a difference between the ICCPR and the provisions of the ICCPR. We're happy with the provisions of the ICCPR being written out in Hong Kong law, but it's a different thing from saying that the ICCPR is inside Hong Kong law, the whole treaty itself. Although there's been a lot of flexibility which clouds the issue a little bit, because of course Hong Kong makes a periodic report to the Human Rights Committee nonetheless. And all of that, and the reason for all of that, and the sense behind all of that is explained in the book as well. But my point is, each side can ascribe whatever function they wish to this instrument. To Britain, to assure people, to assure business, it's this pristine rights charter. To the Chinese side, well, it has only one function, to hand Hong Kong over. And even then, we don't even think it needs a piece of paper. On the diplomatic side, the story in the book begins with Deng Xiaoping telling Edward Heath to go and tell Mrs. Thatcher, please, she has 2 years. She has 2 years to cut a deal. And if we don't cut a deal in 2 years, we're just going to go ahead without you anyway. Thank you very much, guys. That's it. Okay? So we do it in 2 years or we don't do it at all. Now, this is perfectly consistent with the Chinese side saying you're only there because we allow you to be there, or put differently, we don't think we lost sovereignty. Sure, we're not exercising it, but because we're sovereign, we can take our time and we can choose when to exercise our sovereignty, when the time is right. Of course, the British side does not accept any of this, but that's what the Chinese side has said consistently. Now, today, this has raised a completely different controversy. It's a controversy about whether Hong Kong was ever a colony at all. And my answer to that is, well, it depends on from whose point of view you're speaking. But we'll come back to that. So there are two big points on the diplomatic side that are addressed in the book. First, there is this 2-year ultimatum to Ted Heath to communicate to the Prime Minister. And if you read along in the book, this ultimatum was repeated halfway through the negotiations. Now, you can ask, okay, you can set any ultimatum you like, but why do I think, as the author, that the United Kingdom took that ultimatum seriously at all? Why can't I just assume that the British side never took the Chinese ultimatum seriously? I asked that in the book. Can we have slide 15, please? Could the United Kingdom have secured more or called Deng Xiaoping's bluff that if the negotiators failed to negotiate within 2 years, China would have had to impose a unilateral solution? I think what we know from the archives, and this is as far as I can go, because the archives only tell you so much, is that British officials were working desperately to meet that timetable. That's all I could see. That there was all this constant worry about whether we're going to get there within the 2 years. I cannot tell you for sure that the British side did not think, well, they might be bluffing. What I can tell, looking at the archives, is that they rushed to meet that timetable themselves. Secondly, of course, the big diplomatic story is that the British negotiating position had collapsed. It had collapsed completely. So the British Empire couldn't defend British authority over a lucrative financial center, which went accompanied by the sound of a few scratches of the pen in less than 24 months of intense diplomatic wrangling. Let me be clear, if defending British interests was about maintaining some link of continued British authority, then I think the whole thing was a failure. I don't think the whole thing was a failure. It's only a failure if you view it from that perspective, that either you have continued British authority of some kind, or you have none. Now, those are the diplomatic aspects. And what's really interesting is when we get into the legal aspects. Because in 2020, in midst of the national security law being passed, I was asked by Hong Kong U to give a talk. Very sensitive moment, national security law being passed. There was me, there were a couple of colleagues, all my colleagues whom I respect very much at Hong Kong University, my former colleagues, Albert Chan and Fu Leng and Anthony Carty. We gave a talk about the national security law. And in that talk, just looking at things developing before your eyes, I asked a question. I asked what people meant when they said, well, there's a clear treaty breach. There's a clear breach. That's what was coming out of London. My former Singapore colleague I taught Malaysian and constitutional law with many years ago now, the ambassador to Greece, reviewed this book. And he said in the popular press that he thought that what my book really says is that there's no Chinese breach. I actually don't say anything. I don't say whether there is or there isn't, or whether there is a British treaty breach, or whether there wasn't a British treaty breach. I just reproduce everything and lay it out and explain what things mean legally in the background or diplomatically in the background. I don't say anything. And we can talk about why I don't say anything. But maybe the short answer is that nobody in real life says that's a clear breach. Children argue in that way. Lawyers don't argue in that way, not really. So you can ascribe whatever purpose you want to a treaty. That is the whole point of constructive ambiguity. But once you say breach or clear breach, you trigger something else. You trigger a legal question. So you have a diplomatic document. You use certain words. Words do things. You trigger a legal question. Because a treaty is also a legal document. Now, the big question is this. It isn't just a legal document, though. When you say clear breach, are you speaking legally or are you speaking politically? No. Here we come to it. You start off with a momentous, solemn document, but as far as you're concerned, it has a political purpose. Your option D or plan C or whatever you call it has a very powerful political purpose to assure people. When things go wrong politically, some decades later, you don't switch from a political to a legal judgment of it. You still view it politically. And that's where things go wrong. You trigger a legal question, but you're really still seeing it politically. And that's why you're saying clear breach. Politically, that's very convincing. It is because of that that the legal question itself is seen by people to hold no genuine interest. This is what a controversial review in the SCMP said, in fact. In fact, I don't think the reviewer called the review that, but the SCMP put this title to the review and said something like, the treaty is only a piece of paper. And that caused a lot of social media to become very agitated because, of course, being a newspaper, this is clickbait, right? If you have an article that says, oh, you know, the Joint Declaration is just a piece of paper, then all kinds of people who actually can't read the article because it's behind a paywall will get very excited. And hopefully they'll actually pay to read it. But this does no good in explaining what the legal position might be. People, when they say that they are interested in the legal question, in fact, don't mean it at all. So that makes this audience, and you're all still here, unusual. Thank you again for coming. I don't think I can get an audience like this anywhere in the world. So let me now come to today's controversies. They are threefold. Let's get back to the Joint Declaration and the Basic Law just very quickly and talk about whether Hong Kong was ever a colony and whether the Joint Declaration should be suspended or even terminated. Why don't we just terminate it? Today's controversies have had something to do with how the Joint Declaration interacts with the Basic Law, because socialist legality works very differently from the common law. And most of us, I think, are still common lawyers. So we find all this sometimes a bit of a mystery. To the British side, it was clear what they wanted to do. There was always this debate about whether we were going to have a long treaty or a short treaty, and to them, having a long annex would pin the Chinese side down. Can we turn to slide 18, please? We've already seen this slide. This was what I highlighted at the beginning, that during the negotiations, British Foreign Office was quite clear that there was this question about the interaction between the Joint Declaration and the Basic Law and what it means to speak of Hong Kong judicial autonomy when you know that when it comes to the relationship between a center and a region, the center would reserve the power of interpretation. They were perfectly aware of it. And the document that, the original document that I've quoted is on the next slide, slide 19, please, which I've already also shown you. The next slide, please. Yes, that's right. No, go back to the previous slide. Thank you, Alan. Sorry for confusing you. And this is the original document when they say that it has to be that the center interprets Hong Kong's autonomy, because if the issue were allocated, I'll just read the last sentence. If it were allocated to a judicial organ, it would hardly be possible to raise a question as to the aptness of a provision that the power of interpretation should rest with the center. So this is no go. No go. As I had mentioned, there was an attempt subsequently, when the Basic Law was being drafted, to have a court interpret and apply the treaty. But then that idea of having a new international court, a new sort of, how shall I put it, extraterritorial court wouldn't work. Can we turn to the next slide, please? Slide 20. This is the slide that, this is the document that, this is what these documents are about. The declassified records show that following the release of the second draft of what was to become the Basic Law, the United Kingdom had proposed through diplomatic channels that, well, since we can't have another international court, let's insert a provision in the Basic Law saying that you will have to turn to the Joint Declaration to interpret the Basic Law. And of course, that proposal failed as well. And all of this was in 1989, years after the Joint Declaration. That also is my point. It seems strange to us that if you're going to interpret a constitutional document, you go back to the legislature and you ask them what they meant, because common lawyers think that questions about the interpretation of a constitutional document have to do with what words mean. We actually think constitutional questions have to do with what words mean. And we have our own important ways of going about deciding how words mean certain things in a constitutional document, and for that matter, in a statute. That when someone comes to us and says to us, well, we have a very different view about what a constitution means. If you have any doubts about what a constitution means, why don't you go and ask the legislature what it meant? And that essentially is what Article 158 is in the Basic Law, which says that the Standing Committee has the power of interpretation. And of course, the objection to this from a common law viewpoint is that, well, that doesn't work very well. It's almost perverse, because then the legislature can come up with any interpretation to suit a current unanticipated exigency. But judges do that too. When a new constitutional question arises, the judges approach it afresh. It is very artificial to think that the judges do not. When they have to decide what Roe v. Wade means or where we should go on abortion, they look at things afresh. The reason we let judges do it from a common law viewpoint traditionally is because we don't think judges are very powerful. And because they are the least dangerous branch, we'd rather that they do it. And I'm just borrowing from the title of Alexander Bickle's book. But that doesn't mean there is any necessary logic to how we interpret a constitutional document, be it from the perspective of socialist legality or from the common lawyer's viewpoint. There are controversies aplenty. But it is time I move on to the next one, which is this. Was Hong Kong ever a colony? Well, this one's fairly straightforward, because you had people writing in the media that there was a United Nations vote to remove Hong Kong from the list of non-self-governing territories, but it only happened because no one noticed. The credulous layperson's view is that no one actually knows what's going on in the United Nations. And if you remove a territory from a list under which the Committee of 24 maintains surveillance, no one will ever notice, or if they notice, it will be too late. And the credulous layperson may also think that once something like that happens, it is too late to do anything about it. And all of this was written in the public domain. I started my career in the United Nations, and my impression of it, for whatever it is worth, it is that it isn't that farcical. It isn't a comedy of errors. In fact, much of it is very deliberate, rather than being absent-minded. The book addresses this quite simply by asking the reader to look at the votes, to look at the voting divide, and ask how such a split vote could have occurred if everyone was asleep. How could everyone be voting in this concentrated conflict if all of them were asleep? I start the discussion in the book with a letter from the PRC to the Committee of 24 in 1972. And then if we can have the next slide, please, slide 21, Alan. I go on to say, removal from the Committee of 24 list removes the Hong Kong question from British purview. In a telegram 11 years later, Sir Philip Haddon Cave quoted Sir Ian Sinclair, who was a legal advisor at the time, that Britain had never accepted and never would accept that continuance of colonial status contravenes any existing or emerging norm of jus cogens. Well, they're wrong. They're wrong because by 1975, the International Court of Justice had said in an advisory opinion, Western Sahara advisory opinion, that the doctrine of self-determination applies to non-self-governing territories. In fact, by 1995, in the East Timor case, the International Court of Justice considered that saying that self-determination is a jus cogens norm has become an irreproachable proposition. And what I'm suggesting here is that if the United Kingdom considered Hong Kong a non-self-governing territory to be maintained on that list, then by 1975, certainly before 1997, British occupation would have become illegal under international law, according to the majority of countries in the world, and as far as the International Court of Justice was concerned. Now, what this book does is to discuss the African and Asian view that such territories were entitled to self-determination, and there were two kinds of ways of accomplishing that, and they decided that in Hong Kong's case, Hong Kong achieved self-determination by being returned to China through being removed from the list of non-self-governing territories. This involves a hugely interesting and complex area of law, which goes back to late 19th century, early 20th century European debates about whether territories which were not uninhabited, territories which were occupied, could nonetheless be treated by European powers as being uninhabited, and that they would then be open to the taking. And there was debate about whether you needed a treaty to do that or whether you could simply take those territories. But this is not the place to explore that entire debate, which I'll be doing this summer at The Hague. I'm saying that there is this hugely controversial area of the law about colonialism, about its after effects and what we should do about it. And what we had was Sir Ian Sinclair essentially saying that, well, Britain simply does not accept that there is any law against colonialism. Well, the International Court of Justice disagreed. And I think most people would disagree today, and most people would say that, well, we don't think colonialism was right. Whether we can say that there ought to be colonial reparations for something that wasn't considered to be wrong at the time is another different and very interesting matter. But it has to do with what the PRC means when it says Hong Kong never was a colony. They mean that it was removed from the list of non-self-governing territories. Whatever we may think of that, the fact is that it was removed. So people say, well, it was removed absent-mindedly. But it can't be removed absent-mindedly when the votes were split in that way, is all I'm saying. And I say no more than that. How about the last point, suspending the Joint Declaration, because my time is almost up and I have fulfilled my promise to Steve to be fulsome about this. People say we should, actually it's Alex Lowe in the South China Morning Post who said, you know what, why don't we just suspend the Joint Declaration? I was actually very afraid when I was writing the book. I was very careful. I didn't want to characterize Chinese actions as resulting necessarily from any Chinese view of a treaty breach, or British action as resulting necessarily from the British view of any treaty breach. So if London wants to change its immigration policies, while London wants to say at the same time that there was a treaty breach, I didn't link the two issues in the book, because it is entirely possible that London is changing its own immigration policies, not because it is responding in international law terms with a countermeasure against what it considers to be a Chinese treaty breach. It is entirely possible that London feels that it is entitled to design its immigration policies whichever way it wishes. Once we link the two issues, we are one step away from the question of suspension, withdrawal, or renunciation. And I would just ask this audience to imagine what it might mean if one side or the other were to step up, and can we have slide 24, please, Alan, and were to invoke Articles 60 and 65 of the Vienna Convention on the Law of Treaties. This is what happens if you want to suspend or terminate a treaty. You would have to notify. And my impression is that whatever has happened in the aftermath, neither party has notified the other side yet that it wants to suspend the treaty or to terminate this treaty. And the last part of the book has quite a technical discussion of these kinds of issues. So my core message is this: do I answer the question, was the entire Joint Declaration merely ornamental for public consumption? I say in the book that I don't think it's useful to answer these kinds of questions, and I say that in slide 26. What I do say is in slide 28, please. The treaty, however necessary and in its own way remarkable, would always prove insufficient when measured against the United Kingdom's original negotiating aims. The slide contains other things. It contains a hearing in the Foreign Affairs Select Committee in London, where Lord Patton, when he wanted to initiate his democratic reforms, there was a question about whether it was lawful for him to do so, considering the Joint Declaration had already been signed and come into force. And he says in his own early memoirs, I think it's called East West or something like that, he mentions that his view was supported by 3 international lawyers before the Select Committee. And I went into the records on this. It was the distinguished human rights lawyer, Peter Duffy, QC. It was was Peter Keller and Perry Keller and Dr. Peter Slynn. And Peter Slynn mentioned something very important, which I reproduce on slide 30, where the experts were being asked whether the Joint Declaration supported democracy. They answered yes. If it supports democracy, then what's unlawful about the United Kingdom proceeding in that direction before handing the territory over? It was actually Dr. Peter Slynn who pointed out that as far as the Chinese were concerned, looking at what democracy meant in Hong Kong, they were looking at all these functional constituencies that were being applied by the colonial authorities. So it really is open to question what you mean by democracy. What I mean to say is that the name for North Korea is the Democratic People's Republic of Korea. And so that there is this slippage there. But by and large, what I wanted to do with this book was to address a kind of comedy. How can you say it's not binding? It is binding. And then the other side says, I agree it's binding, like a contract to sell me your cow, but I've already paid you $5 for that cow, so I've performed my obligation fully. So you say it is no longer binding? Yes, it is not binding anymore, as there is no obligation. How dare you say that it's not binding? It's this sort of comedy that I was trying to address, that was being presented in the public domain. Of course, lawyers know that we're talking about a fully executed contract, and that's the Chinese view. There are not a whole bunch of slides at the end. They all just have to do with reviews in the Straits Times, the South China Morning Post, Sri Lanka's Island, Malaya's Star, in the Foreign Correspondent Club's Correspondent. There was just another recent review in the China Review. There are a number of other reviews coming out, but complete silence from London. I'll stop here. Thank you very much. Thank you. You've been very patient. Thank you.
Thank you very much, Chin. And you did keep to your promise to the 90 minutes, or just over the 90 minutes anyway. So unfortunately, though, we have run out of time for questions, and I did have a number of questions coming in from our audience. And as you say, our audience did stick with us the whole time as well. So I think you kept everyone enthralled with this. It would have been good to get you on to the idea of tampering with the goods and a little bit more expansion on that, and perhaps even your comparison of Britain to Narcissus as well. Perhaps that would have been something to bring out at the end. But thank you very much for an enthralling presentation, and I'm sure everyone is very interested now in getting a copy of the book and reading through and reading all of your sort of commentary on the development of the Joint Declaration, and of course then the subsequent issues that have arisen. Thank you for that. It only remains for me to thank everyone for coming along today, and also to promote our next events, because this is the last in our Greater China Legal History seminars for this year. But of course, CUHK Law has more events upcoming. So on Tuesday, we have another lunchtime seminar. This time, a very different idea. The SS Ventnor, those of you interested in shipwrecks, and particular shipwrecks that can link New Zealand, Hong Kong, and mainland China together, may be interested in coming along to hear Mr. Keith Gordon, who is a very noted diver and wreck investigator, talking about the wreck of the SS Ventnor off the coast of New Zealand, a tragic New Zealand shipwreck, hungry ghosts, and bit of controversy. So that's on lunchtime on 18th of April on Tuesday. And then we've got the latest in our talks from the Centre for Comparative and Transnational Law, Managing Legitimacy and Stability in Multi-Level Governance. That's on the Thursday, 3:30 till 4:30. And then we have Demystifying ChatGPT with our colleague, Professor Elisa Mick. She'll be talking in our latest CLINS legal tech seminar. And then latest in our property law seminar series will be coming up on the 10th of May with some trust law in the Asia Pacific region. And I know everyone enjoys trust law, so please join us for that. I think, yes, we've still got attributing criminal liability in the murky waters of self-driving cars, driving cars in the Greater Bay Area. And that's the latest in our Greater Bay Area forums presented by our colleague, Professor Michelle Miao. And then that's the final upcoming event to remind you of. There are other events that are available on our website. Information is there and you can sign up for most of our events. And again, most of our events are free to sign up for, so please join us for those. Apart from that, thank you very much for joining us today and giving up your lunch times for this wonderful presentation. Thank you very much, my colleague, Professor Leng Lim, for giving us this great final Greater China Legal History Seminar Series of this year. I look forward to seeing you all in September for the 9th year of our Greater China Legal History Seminars. So thank you very much. Bye-bye. We are CUHK Law. Bye-bye.